All righty, good afternoon, everyone. Welcome to the IU Robert H. McKinney School of Law. My name is Karen Bravo, Dean of the Law School. I will begin by acknowledging that we gather today on the traditional and ancestral territory of the Miami, Potawatomi, and Shawnee people who were removed unjustly. We honor the heritage of Native peoples, what they teach us about stewardship of the earth, and their continuing efforts today to protect the planet. In addition, our campus and our law school stand on the lands of a vibrant Black community, which was also displaced. As the present stewards of the land, we honor them all as we live, work, and study on this campus. So I'm delighted to welcome you to our 2023 celebration of Constitution Day. Constitution Day, or Citizenship Day, is an American federal observance that recognizes the adoption of the U.S. Constitution and those who became U.S. citizens. Constitution Day is normally observed on September 17th, the day in 1787 when delegates to the Constitutional Convention signed the document in Philadelphia. The law creating the present holiday dates to 2004. Before this law was enacted, the holiday was known as Citizenship Day. In addition to renaming the holiday Constitution Day and Citizenship Day, the act mandates that all publicly funded educational institutions and federal agencies provide educational programming about the history of the Constitution on that day. So this is the 10th year, that IU McKinney is observing Constitution Day with a program. To mark this important occasion, today we have 3 distinguished speakers from our full-time and adjunct faculty. They're here to discuss a few of the most recent and important cases decided by the U.S. Supreme Court. We hope that you'll find these topics to be of interest. I will introduce the 3 speakers in the order in which they will speak. We will reserve approximately 10 to 15 minutes for questions after they have all concluded. This means do not ask questions after each speaker has spoken. Instead, please take notes, and then we'll have collective Q&A. First, we'll hear from Adjunct Professor Ken Falk, who is Legal Director of the ACLU of Indiana, who will speak on Creative 303. Second, Associate Professor Aila Haas, who will speak on Haaland, or is it Haaland, versus Brackeen. Third, we'll have Gerard Magliocca, the Samuel R. Rosen Professor of Law, who will speak on Moore v. Harper. Unfortunately, Adjunct Professor and alumna of IU McKinney, Donisha Posey, who's also Vice President and General Counsel of Black Onyx Management, was unexpectedly unable to join us. She sends her deep regrets. Our speakers have agreed to adhere to 15-minute time limit in order to leave time for your questions. So allow me first to express my gratitude to the faculty committee consisting of Professors Florence Roisman and Professor Gerard Magliocca, who organized this panel. I'm also grateful to our Office of External Affairs for all their work in helping us to host this event. Here they are. And now, thank you to our faculty presenters. I will let them begin. Thanks.
Thank you very much. Just to start off with a confession, I'm not an adjunct faculty person anymore. I was from 2000 till this last year, so I'm an adjunct professor emeritus. I didn't know if that's a category, but I just made it up. I always like talking about the Supreme Court. Every year I give some lectures to lawyers about the most recent Supreme Court term, so I'll spend a day reading all the cases from the Supreme Court, some of which I've already read, so I could take notes on them, which is sometimes not the most uplifting experience, but I always like to start when I talk about the Supreme Court with an editorial comment, and I'm speaking to you, lawyers to be. The Supreme Court is the final word, whether it be the Indiana Supreme Court or the United States Supreme Court. They're not wrong. It drives me crazy when I hear lawyers say the Supreme Court is wrong. We can say the Supreme Court has diverted from past precedent. We can say lots of things. But the Supreme Court, you buy into, when you swear in as a lawyer, you buy into the fact that when the Supreme Court says something, that's the law. And having lost in both the U.S. Supreme Court and the Indiana Supreme Court on more than one occasion, I always like to point that out because as lawyers, our job is to support judicial institutions. And we live in a world today when people have come to view the Supreme Court, maybe deservedly so, as a political institution. But when that happens, when we say, well, we know how this case is going to turn out because they're liberal judges and conservative judges, when that happens, and when we talk that way publicly, and we talk that way to people who aren't lawyers, we are undercutting the very foundation that we have sworn to take an oath to uphold. So I feel really strongly about that. I'm not saying I'm happy about all these decisions. I'm certainly not happy about the 303 creative case I'm going to talk about. And there's certainly things to criticize. There are always things to criticize, but they're not wrong. This is the law, and we have to live with it, and we deal with it. And then the great thing about my job is I take what courts say, and then I say, well, how about this? How about that? I can push things along. And that's what we do as lawyers. But having said that, as an editorial comment, having confessed I'm not an adjunct, so you don't need to listen to me, the Alonis case, the 303 creative case, is a free speech case, but it can't be separated from free exercise concerns. And one thing we know about this current iteration of the Supreme Court is that they have pushed the free exercise rights of individuals, the religious rights of individuals, to the forefront so that it becomes a dominating force in cases where it is raised. So let's set the scene. Colorado has an anti-discrimination statute that prohibits public accommodations from discriminating against persons, denying them the full and equal enjoyment of their services based on race, creed, disability, and sexual orientation, among other things. And any business that is open to the public is a place of public accommodation. Very, very broad scope. And this whole issue was up before the court a few terms ago in the Masterpiece Bakery case, where the court, Justice Kennedy, avoided having to decide the case that was presented by Alonis. So 303 Creative is a business owned by one person, Lori Smith, and she is a graphic designer. This is a graphic design place. And she says, I want to get into doing web-based wedding sites so that when you get married, you can have this beautiful site and everything's great. That's what I want to do. She hasn't done it yet, but she wants to. However, she has a sincerely held religious belief that same-sex marriage violates the fundamental biblical, in her interpretation, pronouncement of who can get married. She's willing to work with LGBTQ persons on other things, but she is not willing to create a wedding website for same-sex marriages. Not that she's been asked to do one, but she's not willing to do it. So she brings a preemptive action. She says, look, I want to proclaim on my not yet public site that I'm going to be doing these websites for weddings. I want to proclaim that I'm not going to do same-sex weddings. But I know if I do that, I run afoul of this Colorado law. Therefore, I want you to strike down this Colorado law. And what she argues is that I am an artist. I am putting my work out there, and that's speech. And I'm putting my speech out there, and therefore, the state cannot tell me what to say and how to say it, and I cannot be compelled to give the state's message, i.e., that I'm open to all. The lower courts said Colorado's okay. The lower court said, yeah, okay, we're going to buy the fact that you are engaging in speech. But speech can always be constrained under the very narrow circumstance of compelling state interest, narrowly tailored strict scrutiny. And this meets strict scrutiny because of Colorado's interest in having public accommodations open to all. Everyone agrees when it goes to the Supreme Court that she has standing. I have spent days of my life briefing standing issues, trying to convince a court that my clients are facing injury. Standing seems to have become much easier to find in certain Supreme Court cases, because obviously there's an argument here that you haven't been hurt yet. You haven't even done anything to have the law apply. Supreme Court goes over that. The dissent goes through that, no problem. She has standing. This is a case by Justice Gorsuch. It's a 6-3 decision. Justice Gorsuch says this is a free speech case. It's not a religious case. It's not a free exercise case. It's a free speech case. Here we have Ms. Smith, that's Lori Smith, is the person who owns the company. She's the sole proprietor. She is trying to get her ideas out, her expression out in the form of the website. And a foundational principle of free speech is the government cannot interfere with the marketplace of ideas and cannot compel a person to speak its preferred message. That's black letter law. The First Amendment gives the right someone to speak their mind, generally, or not speak their mind. And her website is protected. Every website she constructs is a mini work of art, as it were. They will be unique, be her expression, and here Colorado's saying you have to speak this way. Now, Justice Gorsuch says, of course, courts are free to have states and municipalities are free to have public accommodations law, as obviously they exist. And states are free to extend public accommodations protections to LGBTQ persons. But they can't do what this does, which is to sweep so broadly as to compel the public accommodation owner to speak in a certain way. It does make a difference that this is a commercial service, that she's doing this for money. The point is, the court tells us, is that Colorado cannot compel an individual to create speech that she doesn't believe in, period. Now, I don't know if you're like me. You're probably not, because most of you are a lot younger. But when I read Supreme Court cases, I have a hard time when I read the majority opinion, usually, of saying, I don't agree with that, because I just sort of take it all in. And then I read the dissent, and I say, well, okay, and then I try and figure out what's going on. It's a rare case where I read it and I say, well, this doesn't make sense to me. I think there are these cases. But it's interesting when you read this, because what Justice Gorsuch is postulating is that Ms. Smith is Michelangelo, right? He is creating this monumental work of art for each person individually who comes in. And if you view it that way, well, obviously the state can't tell Michelangelo that David has to have pants on, for instance, although I'm sure there's some governors of southern states who might think that's a good thing to do. That was completely gratuitous, and I apologize. I don't really apologize. But that makes sense. But here comes Justice Sotomayor, who dissents. And her dissent is very strong. Strong's the wrong word. Her dissent draws on a completely different approach. She says, number one, what are we talking about here? We're not talking about Michelangelo. We're talking about McDonald's. We're talking about a business, right? She is not creating art out of nothing. She's getting paid. And this is the first time the court has ever held that a business open to the public has a constitutional right to refuse to serve members of a protected class. Now, Justice Gorsuch says, well, that's not the case at all. This woman is willing to do everything for LGBTQ people. She's not turning away LGBTQ people. She's just turning them away to this particular service. And Justice Sotomayor, she goes through the history of the civil rights movement. She goes through the history of discrimination against LGBTQ persons. She talks about an early Supreme Court case where a person in the South was refusing to serve African Americans, but allowed them to eat at the back. They just couldn't come in the front of the restaurant. And she said, well, don't tell me that Laurie Smith is willing to, do an invitation for you if you're gay, because if you're wanting a website, you got to go to the back of the restaurant. And she talks about the harm that has been done historically to denial of rights in public accommodations, from Jim Crow, with civil rights cases, which preceded Jim Crow in the 1870s, on up through the Civil Rights Act in 1964, and cases based on those. And she says, look, what are we talking about here? We're not talking about speech. We're not denying her the right to say, I don't think gay people should get married. In fact, she could tell everyone that I will put on every website I do not support same-sex marriage. Every website, both, as long as she does it for both same-sex and opposite-sex marriages, no problem. She's not impeding her speech. We're impeding her commercial activity. And the act of discrimination, Justice Gorsuch says, has never before been deemed to be protected expression. And again, Justice Gorsuch, they go back and forth, very, very directly. I mean, sometimes when you read a Supreme Court decisions, there's only sort of oblique references to dissent. But here, they go back and forth, arguing. And Justice Gorsuch says, well, no, that's not right at all. We're not talking about the act of discrimination here. We're talking about her personal expression. You don't like it. I may not like it, but it's still expression protected by the First Amendment. And Justice Sotomayor comes back and says, well, look, if you choose to be open, you're not Michelangelo, right? Michelangelo can turn anyone he wants because Michelangelo doesn't have a sign saying, Michelangelo, I'll carve for anyone. If you open your door for everyone, Justice Sotomayor says, the state can say, look, as a condition of that, you can't discriminate. Moreover, she says, even if we do talk about strict scrutiny, remember, lawyers to be, when you're dealing with constitutional issues, the first question always is, what scrutiny do we apply, right? Because if you're a plaintiff and you get this strict scrutiny, you're happy because almost always strict scrutiny means the state loses. You have to show compelling state interest that is narrowly tailored or the least restrictive alternative, depending on what case you're reading, means the same thing. But Justice Sotomayor says, look, even if you say that, even if you say this is pure speech, which it's not, but even if you do say it's pure speech, and you apply this strict scrutiny, Ms. Smith should still lose because the state has a compelling interest in making sure that public accommodations are open. And what Justice Sotomayor ends up saying, and I think this is a good point, which I don't think Justice Gorsuch really responds to, is, well, what if tomorrow the website designer says, my religion is that I don't make web designs for interracial couples? What if, and Masterpiece Bakery was a case out of Colorado, and the court found that baking a cake is a work of art. I don't like serving Jews. My religion, not I don't like it, I'd love to, but unfortunately my religion prohibits me. What do you do with that case now? If you say here that free expression trumps the state's interest, and if you say that everything that you do, even if it's a commercial enterprise, is free speech, not conduct, where does it end? I don't know, but I think we can expect to see cases where people are challenging public accommodations laws by arguing that their religion compels them to not honor this part of the law or that part of the law. And as with always with Supreme Court cases, we'll have to see how it develops. But I will desist. Thank you for your attention.
Good afternoon. I am so delighted to be here to talk about Indian law. I don't get to do it as often as I would like, and I'm sure that's why you all are here too, because you don't get to learn about it as much as you'd like. I was invited to talk about the Haaland v. Brackeen case that came out over the summer, and I promise I will do that. But as is the case when we were talking about tribes, about Indian status, indigenous rights, I can't get to what this decision means, how is the law interpreted, before offering some foundation to what is a tribe? Who is an Indian? Isn't it racist? Isn't that word not allowed to be used? And so, as a non-native person who is very proud Iranian American, by the way, works and hopefully serves as an ally and advocate for indigenous rights and tribal sovereignty, it's important that I acknowledge that my lived experience is not as an indigenous person, and that I could perpetuate some of the biases and structural violence that I purport to fight against in my work, in my research, in my practice. I also want to, let's do some editorializing, acknowledge the fact that other jurisdictions within the American family of governments don't have to stand up here and say, let me explain to you what a state is. Or this is what local governments are. Yet, tribes as sovereign nations are often excluded from the discussion, from our legal education. And as I will share with you towards the end of my talk, even in states with relatively few indigenous people, only one federally recognized tribe in the state of Indiana, the Pokagon Band of Potawatomi. The reservation lands are on the Michigan side of the border. That's why folks don't know there's a federally recognized tribe in Indiana. Indian law matters everywhere. 574 federally recognized tribes within the boundaries of what we now refer to as the United States. There are, give or take, 80 tribes that don't have any recognition or have state recognition, but these are not mutually exclusive. Tribes are sovereign nations. Tribes are sovereign nations. So I got some of my 1Ls in the first row. We're going to get to a chapter in our textbook where our textbook author says the only sovereign governments of the United States are the federal government and the states. And you're going to cross it out and you're going to say wrong. Tribal sovereignty is recognized by the federal government. A significant amount of case law on this. Tribes maintain jurisdiction over their lands and people. They pass laws. They have adjudicatory systems. They maintain governments and agencies. What do we mean by sovereignty? The right of tribes to make their own laws and be ruled by them. These rights of a sovereign are not a grant from the federal government. And so, as I also will tell my students, if anyone tells you that the U.S. Constitution grants tribes sovereign powers, you kick them in the shin, you step on their feet, because that is very incorrect and perpetuates a misunderstanding of the law that damages tribal rights and tribal sovereignty. Tribal sovereignty is an inherent power that predates the U.S. Constitution. They've been exercising it since time immemorial. As a result of colonization, of genocide, of European contact, what has happened is we have a very, frankly, strange framework, not just in the United States, but many countries around the world, where tribes as governments and their rights to govern are recognized, but with strings attached. So, yes, tribes are sovereigns. Their sovereign powers are inherent. Social compacts between the government and their citizens, and yet federal Indian law says, but in exchange for recognizing your sovereignty, we're going to tell you what to do once in a while. And so much of my practice, my livelihood, is parsing out when and how the federal government is allowed to say what a tribe is allowed to do, particularly what that means in the context of conflicts between states and tribes. Federal Indian law is a body of federal law that governs the rights, relationships, and responsibilities between tribes, state, and federal government. Much of our groundwork for our body of federal Indian law and the government's role in supporting tribes as sovereigns is about protecting tribal governance from state infringement. Maybe the biggest string attached in federal Indian law is, even though tribes are sovereign nations, that Congress has what's referred to as plenary power. I've got one of my federal Indian law students. Trent, help me out. What's plenary power? Yeah, complete, absolute. Congress has plenary power to legislate on all matters concerning tribes or Indians. And Congress has used their plenary power many a time. And that is why, in the context of criminal law, in the context of civil law, in the context of taxation, in the context of environmental protection, in the context of family law, you could have different sets of rules and standards for adjudicating conflict of, oh, does federal law apply here? Oh, is a state allowed to pass a law here? Does it apply on tribal lands? Plenary power has been used to reduce the scope of tribal sovereign powers. And Congress is allowed to do that either expressly or implied by dependent status as a virtue of being conquered. When I say implied, what does that really mean? You know the answer. If it's not Congress doing it expressly, what does implied mean? Yeah, there's a court, judicial action that says, Congress didn't say a tribe can't do this, but, you know, they've been conquered, so they probably shouldn't be able to do this. You'll have all learned, maybe not in this building yet, maybe in a middle school classroom, about the Supremacy Clause. The Constitution, laws that are made are the supreme law of the land. So often what is missing when we are taught this list is the fact that treaties is also on that list. Treaties that have been made are the supreme law of the land. The Supreme Court has interpreted that plenary power, what is many scholars will say, although Brackeen kind of muddles up the waters a little bit, an extra constitutional doctrine, allows for Congress to abrogate treaty rights. One other piece that is very unique in the context of federal Indian law is the trust responsibility. It is a commitment the federal government has made in light of history, case law, treaty obligations, statute, to support tribes both in the context of protecting tribal assets like tribal lands, but also, or tribal funds, but also a moral responsibility. How the federal government has chosen to use its plenary power and its trust relationship responsibility has varied over the years. Oftentimes, the law was used as a weapon. We are today in the self-determination era, and the Indian Child Welfare Act, the case that we are going to be talking about in the context of the Brackeen decision, was passed during the self-determination era, the time where Congress was using its plenary power to support tribes. Why did Congress feel the need to pass legislation regarding family law? Much of the history of relationship between tribes and the federal government has been assimilation, whether it is through boarding schools, forced removal of Indian children into schools, often off reservation, through family relocation programs, through the prohibition of, both under the law and policy, of wearing your hair in the traditional way or speaking your traditional language. The founder of the Carlisle Indian School, the first non-reservation boarding school, these are pictures from there, his policy was kill the Indian, save the man. And so generations of Indigenous children displaced. Even after the end of assimilation policies, through boarding schools, family relocation programs, there was consistent, chronic removal of Indian children from their homes into non-native white families at the state level. And so Congress intervened after much advocacy from tribes, from Indigenous people, to establish this law, acknowledging that there is no resource that is more vital to the continued existence and integrity of Indian tribes than their children. If children or Indigenous children continue to be taken away from their homes, who is left for a tribe to govern? Even after the passage of the Indian Child Welfare Act, ICWA for short, we continue to see disparities in the placement of Indian children, the removal of Indian children away from their family members, away from their tribes, at higher rates than any other racial ethnic group. And so while ICWA has absolutely been very beneficial to Indian country, it has not stopped the flow away of Indian children into non-native homes. ICWA applies to Indian children. An Indian child is one that is either a member, eligible for membership, or one of their parents is a member of a tribe, one of the federally recognized tribes. And it applies to child custody proceedings, adoption, foster care, pre-adopted placement, termination of parental rights. Creates a jurisdictional scheme to allow for tribal courts to have exclusive jurisdiction when the child is domiciled within a tribe's reservation, and to allow for tribal state concurrent jurisdiction in instances where the child is not domiciled on reservation. ICWA provides both procedural safeguards, notice to a tribe that one of their members or eligible potential members is involved in a proceeding related to their custody, allow for intervention by tribal courts into state court proceedings if there's not tribal exclusive jurisdiction, but also substantive standards, prioritizing placement within, even if there is grounds for removal from parents, placement within other members of the tribe or other Indian families. ICWA is remarkably unique because it is federal law, federal family law, an area that is traditionally in the purview of states. It's unique because it adds what some people call the third parent, that a tribe, not just mom, dad, parent one, parent two can intervene, but also a tribe can intervene and have a say and a right to speak to the placement of this child. A few years ago, you might remember a very controversial case related to the application of ICWA, maybe Veronica. I'm not going to chat about it because we don't have time. I've already been rattling away. Chris Ross Nemo, the lead attorney for the Cherokee Nation, that intervened in this case, Associate Attorney General, Cherokee Nation, within the boundaries of what now referred to as Oklahoma, has posted, and I have kept folks that want to dismantle ICWA fit into 4 categories. Non-Indians who want to adopt Indian kids, people who profit off of number 1 because the adoption industry is very profitable, non-Indians who want to weaken tribal sovereignty, and people who profit off of number 3. I also want to add, because maybe if I had said that I'm going to talk about Dobbs, this room would be packed. Footnote 46 in the Dobbs decision came out a year before the Brackeen decision, literally talks about the domestic supply of infants. Domestic supply of infants. As it is a product. These children are a commodity. And it was perverse to me that a decision that was going to inequitably limit access to abortion for Indigenous people was going to be followed up, we thought, by Brackeen, which would have also limited the role of tribes in determining the placement of Indian children. So, increasing the supply, making it easier to remove those children. The Brackeen decision has to be contextualized within our recent Supreme Court jurisprudence, and people have feelings about Indian law, and they have feelings about whether tribes should exist. And the current court has issued opinions that my colleague would say have significantly departed from existing established precedent. And I, much less honorable of an attorney, will say that such decisions are wrong, or maybe more appropriately, Cocoa Puffs, ridiculous. So, Haaland v. Brackeen. Is the court going to go McCurt style, support tribes, tribal sovereignty, Indigenous rights? Following 3 non-native couples, birth mother of 1 child, and 3 states initially, or original plaintiffs, sued that ICWA was unconstitutional. They had a favorable decision in a Texas federal district court, the first time a federal court deemed ICWA unconstitutional. 45 years. First time a federal court said unconstitutional. And then the Fifth Circuit, who presents itself in many cases that seem to deviate from existing precedent, didn't agree entirely with everything that was done at the district court level, but effectively said, yeah, some of this is not constitutional. So it gets to Supreme Court, and we are sitting on edge. And ended up being a 7-2 decision written by Justice Barrett. And the court said, in terms of does Congress have the authority, particularly plenary power, a totally established precedent, and all federal legislation would not exist related to federal Indian law if Congress didn't have plenary power. It's just Cocoa Puffs. But that was up for debate. Said federal law preempts state law. Congress has plenary power. They can do whatever they like in regards to Indian affairs, with some limitations. It's not absolute. Commandeering, relatively recent doctrine that's been used frequently in the last few decades. Does it take away states' rights to adjudicate disputes, in this case, family law? Supreme Court says no. Does ICWA, in treating Native children differently or prioritizing Indian families over non-Indian families, so a race-based distinction in the law, violate equal protection? In this and in the non-delegation, Congress delegating their authority away regarding one particular kind of goofy provision of the priority placement, the court said the plaintiffs lack standing, but their significant amount of precedent that has always said being Indigenous, being a member of a tribe, is a political classification. Justice Gorsuch added a concurring opinion. He was the majority author in the McGirt. Has always positioned himself as an expert in federal Indian law because he was in the 10th Circuit and heard a lot of Indian law cases. And frankly, he's been consistent in that regard and encourages to say that there needs to be more discussion of the history of assimilation and forced removal and what that has meant, literally in boarding schools, the murder and sexual abuse of so many Indigenous children. And then we also had a concurring opinion from Justice Kavanaugh that said, it's not that there are no plaintiffs out there that could have standing, it's just these plaintiffs don't. Can they demonstrate that they've suffered an injury that's traceable? So the argument is, am I being harmed as a non-Native person if I can't adopt an Indian baby. Who wants to make that argument? I wouldn't want to, personally. I've gone over my time, so I want to just acknowledge the fact that this was a victory in upholding the constitutionality of ICWA for tribes. That's your thing, supporting tribal sovereignty and indigenous rights. And the pundits out there were like, oh my gosh, look at the Supreme Court. This is just such a great decision. Without talking about the Cocoa Puffs decision, like Castro Huerta from the previous term, Arizona v. Navajo Nation, a water rights case that was not resolved in favor of the tribe. Another case, not even a close one, 8-1, regarding the application of bankruptcy code in terms of tribal sovereign immunity. So this was a victory, and maybe the most important one since McGirt, but man, we got a lot of really bad decisions out there too. And I think with that, I'm going to end there and happily pass the baton over to my colleague. Thank you.
Okay, well, thank you everyone for coming. I am here to talk about Moore versus Harper. I'm here to talk about Moore versus Harper, which was a case from the Supreme Court last term that rejected the so-called independent state legislature doctrine. Now, I come here to praise Moore, not to bury it, okay? I'm going to praise this opinion by the Chief Justice because it got almost everything right in doing the analysis, and maybe everything right depending on how it gets applied next year or in subsequent years. So, briefly by way of background. The case arose from North Carolina. The North Carolina legislature, as part of redistricting, created a map. The map was challenged in the state courts of North Carolina as being a partisan gerrymander. Now, a few years ago, the U.S. Supreme Court held that partisan gerrymanders could not be challenged in federal court, that it essentially raises a non-justiciable political question, but they left open the idea that state courts pursuing or interpreting state constitutional provisions could reach the merits and say that certain districts were drawn in too partisan a way. So the North Carolina Supreme Court proceeded to do that. They said that the map that had been drawn was a partisan gerrymander and basically threw it out. Okay, now, the question then was raised in federal court as to whether the North Carolina Supreme Court had the power to do that. And the argument was something like this. The Constitution says that the legislature of a state has the power to basically deal with issues like state redistricting, or at least that has been the sort of tradition that has been followed. And that when the Constitution uses the word legislature, in that context, it means the legislature and only the legislature. Thus, courts have no power in a state to review what the state legislature has done with respect to a districting map, because that is simply a legislative function only, right? So that would mean, in effect, no state judicial review of these maps from congressional districting. Now, this is pretty consequential because every 10 years, we have redistricting in states across the country. There's a lot of fighting about what the maps will look like. And then, invariably, we have litigation, often in state court, and now really only in state court, about whether the maps are valid or not. So if the court were to have held that state courts had no power to review state legislative districting maps, that would have marked a pretty significant change in the practice that we've had in districting and reapportionment up until now. Now, When you think about this claim, first thing to say is that sometimes when the Constitution uses the word legislature or the word Congress, it means only the two chambers of the state legislature or of the Congress. Now, an example would be the constitutional amendment process of Article 5. It says that Congress proposes amendments, right, if you get a 2/3 vote in each house, and that you need 3/4 of the state legislatures to ratify the proposal for it to become part of the Constitution. The president and state governors, federal courts, state courts play no role in that at all. Congress means Congress, right? State legislature means legislature only. Now, in other places, though, when the Constitution uses the word Congress, it doesn't just mean Congress. So, for example, something like, Congress has the power to do something, right? Well, yes, but Congress only has the power to do something if the president signs the bill that Congress has enacted, or Congress manages to override a presidential veto with a 2/3 vote in each house. So Congress doesn't mean just the two chambers of Congress. It means sort of the lawmaking process as specified in Article 1, Section 7. Now, the same could be said to be true for state legislatures, right? That when the Constitution uses the phrase legislature or state legislature, it means the state lawmaking process that would include, say, the governor, for example, and courts, right? So sometimes legislature means only the legislature, and other times legislature means kind of the lawmaking process as specified in the Constitution of a state. Now, which meaning is the correct one for understanding redistricting? So, one side of that argument is to say, well, you should read the word legislature literally to mean only the legislature, okay? Now, the trouble with that is that there was a case from about 90 years ago, written for a unanimous court by the Chief Justice at the time, that said, well, but the governor can participate in decisions about districting through signing it or vetoing it. And indeed, that has been the practice since nearly the beginning of the United States. That is, when a state draws new districts, that's a bill that gets enacted by the state legislature, and then it goes to the governor, and then the governor, under the state constitution, signs it or vetoes it. And if there's a veto, then the state legislature has to either override the veto or go back and redo it if they can't override the veto. So, in the districting context, it was very hard to say, given that precedent, that legislature means only the two chambers of the legislature. So the argument instead was presented that, well, no, it means just not courts, right? That was at least one part of the argument. I mean, it was a little more complicated than that, but essentially it was conceding that, the legislature means legislature plus governor, but it doesn't mean courts. And that you could draw a distinction between, say, the elected branches maybe, or the judiciary, or you could draw some distinction about substantive ways of looking at districts and versus procedural ways of thinking about them, and so on. Okay. Now, the other side of the argument was to say, well, yes, but the trouble is that courts have also been involved in redistricting ever since the beginning of the United States in various ways. Either they were available to hear challenges, or they did hear challenges, maybe they accepted them, maybe they rejected them. Moreover, that's because that's how state law works in every state. That is, you have a law enacted by the legislature. It can be challenged in court pursuant to the state constitution typically, and then the state courts rule on it. So why is this any different? Right? Okay. Now, look, part of what motivated this suit and got people interested in this issue is the idea that maybe you think that in a particular state, the court is acting itself in a partisan way. So the argument was, look, there was a Republican legislature in North Carolina that drew the map. There was a Democratic majority on the state Supreme Court that threw the map out. Okay, so really, that's either not real judicial review, no, it's kind of lawless, or it's a reason to be suspicious of state courts acting under their state constitution. So therefore, we either need to say no state courts can do that kind of review, or alternately, that federal courts ought to sit in review of state Supreme Courts and essentially judge whether the state Supreme Court has correctly interpreted state law or not. And so those were some of the arguments that were in the mix. Now, an interesting fact about this case is that in the elections last fall, North Carolina has basically like an elected Supreme Court, right? Well, the Republicans won back control of the state Supreme Court from the Democrats, and the new state Supreme Court in North Carolina granted a petition for rehearing on the case where the prior court had thrown out the map, and then they issued a decision saying, well, no, actually, we're going to throw out the throwing out of the old map. Now, this led to the thought that perhaps Moore versus Harper was moot in the U.S. Supreme Court because, well, now the original point of the suit was kind of lost because the state court had reversed itself. So the Supreme Court held that this was not moot and that they could decide it. Now, one version of this would be to say, well, at a certain point when the Supreme Court has already heard argument and they've invested a lot of time in the case, they're just going to decide the case. And they're not that interested in, some argument that they don't have jurisdiction anymore. Another question might be something like, well, gee, if a state Supreme Court can remove jurisdiction from the U.S. Supreme Court by reversing itself, doesn't that create all sorts of possibilities for mischief where, you see how the oral argument goes in the U.S. Supreme Court, and then you say, uh-oh, didn't look too good. Maybe we ought to grant a petition for rehearing and moot the case, right? So anyway, so part of the opinion just says, no, the case is still live and we can decide it, and then they proceed to decide it on the merits. Okay, so what do they decide on the merits? They say legislature, in the context of redistricting and sort of state regulation of elections more generally, is, in fact, saying the state lawmaking process as defined by the state constitution. Includes the governor, includes judicial review, includes whatever the normal processes are for analyzing a claim. And therefore, the North Carolina Supreme Court could review the map that the legislature had drawn, and so can any state court if the state constitution permits that. Okay, now, that left open the question of, all right, but what if we think the state Supreme Court is acting either in a partisan way, a lawless way, they just totally got state law completely wrong? Like, what then? So what the court says is, well, there might be some situation where that's true, but we don't know what the standard for judging that should be, so we're not going to give you a standard. Talking about standards of review, right? Okay, so that doesn't totally foreclose the possibility of federal court review of state Supreme Court decisions about state election law, but it did seem to send a message that they weren't that interested in doing that, or that you'd have to have an awfully good case to say that federal court should intervene. Now, part of the backdrop of this is not just about congressional elections, but it's also about presidential elections. So we're going to have a presidential election next year, and every presidential election now, you get a certain amount of litigation in state court saying the state election officials or maybe state courts, they're not really following what state election law is. They're giving people too much time to vote, not enough time to vote, this, that, and the other, right? And, well, those cases go to state court, and they're resolved. Now, the question is, okay, but what if federal courts want to jump in and try to resolve what state election law is? Okay? So the good news is the court seemed very reluctant to take on that role, right, from what it said in Moore versus Harper. The bad news is they didn't foreclose it. Therefore, one can expect lots of people to bring claims in the 2024 election, arguing that a state court got state law so wrong about the election that a federal court should step in. Now, it's an interesting question. I mean, Professor Sullivan is here, and I'm sure it's fair to say that none of the 9 justices know anything about the Indiana Constitution. And if they were to come in and say that the Indiana Supreme Court had misconstrued the Indiana Constitution or Indiana election law and done so clearly that no one could doubt that that was so, he might be skeptical, right? And I think that's a general problem for this sort of issue, which is why normally, right, federal courts do not opine about what state law is. State courts do. That said, I mean, you might say maybe they had to leave at least a little bit of wiggle room for themselves for some extraordinary situation or to get the 5 votes they needed to write this opinion. So, we could say, okay, if you like 95% of what they said, and then this part maybe not quite as much, hey, that's the price you had to pay to get what is mostly a correct determination about the fact that state legislatures are not just free agents that can do whatever they want without judicial review in the context of election regulation in their states. So with that, I will stop.